28, 2 minutes.
Oh, thank you, man. All right, good afternoon. Welcome to Subcommittee of Judiciary Non-Civil. Representative Sains, you mind opening us up in a word of prayer?
Dear God, we come to you humbly in request to give us the grace to know what is in your glory, what is in the best interest of all people of Georgia. In your name we pray, amen.
Amen. All right, welcome. I think everybody had time enough to sign up. First, we will hear House Bill 1426. Representative Moore, if you want to come sit right there. And for the committee members, Representative Moore has provided us some material. Welcome.
Well, thank you, Chairman. Appreciate it. Do you have more folks online? This is it right now? It's today.
All right now.
It's today a hearing only, or are we voting?
We will have a hearing only today.
Okay. All right, great. Well, thank you, guys. Appreciate the opportunity to formally present to you on the record with folks in the room. I'm here to present House Bill 1426, for which I am the lead co-sponsor or lead sponsor. My co-sponsors on this bill include Chairman Werkheiser, got Chairman Gunter, who's here. Representative Sains has joined the bill as well. Representative Scott Holcomb is on the bill, and Mitchell Scoggins. So I'm very proud of this collection of co-sponsors that we have on the bill, and happy to present to you today. So although this bill involves a very heavy topic, what the bill proposes to do, I would describe as very simple. There is currently, in my opinion, an error in the way that the current statute is written as it applies to the death penalty in cases where there is a defendant who may have an intellectual disability. I know I've spoken with some of the members here about this individually, but back in 1988, this body, this committee, wrote the law that is currently on the books and revised it several years ago. There's a standard of proof that defendants with an intellectual disability have to achieve in order to prove that they are in fact intellectually disabled, which would exempt them from the death penalty. They can still be found guilty of the underlying crime, but they would be exempted from execution. This is the federal standard through Supreme Court precedent that it's considered a violation of the Eighth Amendment to issue cruel and unusual punishment, and the execution of anyone with an intellectual disability has met that standard under US precedents. The problem is that in Georgia, we have a statute on the book that conflates the issue of guilt with intellectual disability. So while the standard of beyond a reasonable doubt is perfectly appropriate for finding of guilt, we have inadvertently created that same standard to apply to the question of intellectual disability. The original author of that law, the lawyer who wrote that language, has gone on the record since then saying that he made a mistake. It was originally designed to create a category for people with intellectual disabilities to make sure that although they did have to be accountable for their crime, that they could also get the services that they need. But that's not what happened. We instead created a statute where it is impossible, virtually impossible, for anybody to be found both guilty of the underlying crime and intellectually disabled in a way that would exempt them from the death penalty. And that's because of the way that the statute is worded. That was not the intent of the law when it was originally drafted and passed through the Judiciary Non-Civil Committee. The reason this issue came to light to me was because of a Georgia Supreme Court opinion that came out last year. It was one of the last opinions that Judge Melton wrote. And ultimately, the Supreme Court reviewing this law chose to uphold it. But there was some compelling language in a concurring opinion put out by Judge Namias, essentially begging the legislature to review the statute and rewrite it. And that's why we're here, right? I took that explicit language, which I'll point out to you in a moment, and created this bill to bring Georgia into the national standard in terms of how it applies the death penalty to defendants who have a proven intellectual disability. So some of the things in your packet, in addition to some of the key points that I've provided to you, which many of which will be reiterated by some of the speakers who are to follow me. In your packet, you will find, first of all, a copy of the bill. I'm sure you guys have been provided one, but I just want to make sure you had it, that lays out exactly what we are proposing to put into statute. This bill was originally crafted after a proposal back in 2018 by a Republican member of the Georgia State House. I adapted it and am reintroducing it to you now. The second thing you'll find on the right side of your packet is a New York Times article, which came out last month. Well, it's March now, so this came out in January, that I thought did a really good job of clearly explaining what the issue was and what the history of this bill was. And you'll see I highlighted some of the language there. If you look at the very, very bottom, this is a quote from Jack Martin, the attorney who was working on behalf of the defense counsel at the time, saying he dropped the ball. He said, and this is all quoted here, he said, "It was sloppy draftsmanship, pure and simple," Mr. Martin said. "I don't think anybody intended that to happen." If you flip to the second page, it goes on to say, that in Georgia, not a single person convicted of intentional murder has prevailed in trial at establishing that he is intellectually disabled. That is how difficult our current standard of proof is, that we require defendants to prove beyond a reasonable doubt that he or she is intellectually disabled. That is not a standard that's applied to defendants. That's a standard applied to the state, but we're applying it here to the defendants. And that makes Georgia an outlier. You can see in this article, it also points out that in all of constitutional law, Georgia stands alone on this issue. We are the most punitive on the books when applying the death penalty towards people with intellectual disabilities, which again is unconstitutional per Supreme Court precedent. The other two items you will find in your packet, these are not the prevailing opinions from the Young case, the Georgia Supreme Court case last year, but I printed them out for you because I think they're worth reading. We've got the concurring opinion from Judge Namias, who again ultimately decided to uphold the ruling on the Young case last year. But I want to point out some compelling language that he added in his concurring opinion. If you flip to the second page of the Namias decision, he says that although he is concurring with the majority opinion, that the one issue he has the biggest problem with is the part about the Eighth Amendment protections. And he says that the issue that is closest, as evidenced by Justice Bethel's dissent, which I also have in the packet we'll get to next, that he has the least confidence in is in the result is the continued viability under the Eighth Amendment of the Constitution of Georgia's unique statute placing on the defendant the burden of proving his intellectual disability beyond a reasonable doubt. So already he's signaling that he's got an issue with this. He's going to concur with the opinion, but he's got an issue. But the real kicker, guys, flip to the very last page of the Namias decision. This is what caught my attention and the attention of other advocates in this arena. He says, if the General Assembly takes a further humane step with regard to criminal defendants who are potentially intellectually disabled, I would embrace that change. Look, I don't know how often a Supreme Court justice writes language like that, but that's pretty strong language, if you ask me. He's asking us, take another look at this, because there may be some Eighth Amendment issues going on here. I also included the opinion from Justice Charlie Bethel, who you guys know used to be a member of the Georgia State Senate. He dissented in this opinion. He was the lone dissent. And the reason being that he believes that the Georgia statute as it's currently written is in fact unconstitutional. And he had some pretty stark language in here too, some of which I highlighted for you. If you look on page one, what's numbered page 141 on here, he acknowledges that the question before us then is whether Georgia's requirement that a defendant prove his or her own intellectual disability beyond a reasonable doubt creates, quote, an unacceptable risk that an intellectually disabled person will be executed. He says, Justice Bethel says, here the evidence of such a risk seems plain. And I know he's the lone dissent, but for him, the question of this seemed the answer to this question seemed very plain. If you flip to what's labeled as page 143 in the Bethel decision, this is where it really cuts to the heart of the matter here in terms of changing the standard of proof from beyond a reasonable doubt to what I'm proposing here, which is preponderance of the evidence. He says in his opinion, the U.S. Constitution protects all intellectually disabled offenders from execution under the Atkins case, which set the standard or reiterated the standard that we cannot execute people with intellectual disabilities. And Georgia's standard effectively limits the constitutional right protected in Atkins to only those who suffer from severe or profound intellectual disability, such that their disability is not subject to any real dispute or doubt. But as the Supreme Court has determined, the 8th and 14th Amendments must afford protection to an offender whose disability is less obvious or profound, which is why I'm proposing the preponderance of the evidence standard, as opposed to clear and convincing, and certainly, moving away from the beyond a reasonable doubt standard. It's because there is Supreme Court precedent saying that, that the death penalty should be exempted even for people who do not have, an intellectual disability that would fall under, for example, the clear and convincing standard. This is for everybody who has a legitimate intellectual disability, even those who might be right on the cusp, where they are more likely than not intellectually disabled, but subjectively, if there's any question, but there is enough evidence showing that they are, that a jury can find that they are in fact intellectually disabled, and therefore they would be exempt from the death penalty. They can still be found guilty. They can still go to jail for life, but we simply will not execute them. One of the things that about the death penalty, particularly as it applies to people with intellectual disabilities, is that some of the Supreme Court precedent, like the Atkins case, doesn't prescribe to the states how to do this. They say, don't execute people with intellectual disabilities, but you guys figure out how to determine what that is. Well, that leaves a lot of room for states to figure out what works and what doesn't work. Georgia at one point was the national leader in proposing compassionate laws to exempt people with intellectual disabilities. Georgia used to be on the forefront of this, but because of these changes that occurred a couple of years ago, we swung the complete opposite way. We became one of the worst states, one of the most punitive states, and we have the author of that bill, the author of that language, going on record saying he made a mistake. Well, now we have an opportunity to correct that mistake. We are not getting rid of the death penalty, right? That is still on the books, but we're going to do what I believe is the right thing in making sure that we are not violating anybody's Eighth Amendment protections against cruel and unusual punishment, and just doing better as a state. Death penalty laws are really left up to the states to determine, and some of the legal language around that is that, states should evolve their language, right? That there should be evolving standards of decency. And guess what? we get to decide what that standard of decency is. We have that power. And we got to get the governor to sign off on it too, but we have that power. So I'm asking this committee to consider what's being proposed in front of you today, to consider it favorably, and let's do the right thing. I'm really hoping this can be this year's like really good, feel good bill that will get broad bipartisan support, and we can leave here knowing that we did something good. This will be this year's hate crimes bill, okay? Anyway, I'm open to answering any questions, of course. I know we got a lot of people that want to speak to the bill, so I can take questions now, or I can come back after other speakers have had a chance, whatever the chairman's will is.
Yes, we do have questions. Chairman Burchett.
Thank you, Mr. Chairman. Thank you, Representative Moore. I appreciate you for bringing this bill, and thank you for the conversations we've had before this this hearing here. I know you are working diligently to get this issue remedied. And I wonder, did you in your conversations, have you had any conversations with any of the justices or anybody on that side about this issue?
You know, I actually approached Judge Namias when I saw him at a Georgia State Bar event to ask him, you know, hey, I heard maybe you talked to Chairman Burchett about the death penalty issue. And I think he's the type of guy who just acknowledges the separation of powers and didn't want to muddy the waters there. And I certainly respect that. And so that's what I decided to do in this case, was just respect the separation of powers, take what they put in their opinions and bring it forth to this committee.
Thank you. I appreciate that.
Yeah.
Any other questions? I have one. Representative Moore, I appreciate you providing these opinions of Justice Bethel and Justice Namias. It was interesting to me. If you look with me, this is on page 133 of Justice Namias's concurring opinion, and it certainly will make me miss him as the good, strict constructionist jurist that he is on our bench. There was an interesting line here as I was reading through, and if you'll read with me, it says the reasoning of the United States Supreme Court's decisions does not bind lower courts. However, only the holdings govern. That to me was very interesting. And although I did read what he had noted last there in the end of his opinion, it was very interesting to see that noted there. Could you kind of parse through that for us?
Yeah. So there was, I believe, some circuit splits into whether lower courts have to abide by the reasoning put out in a majority opinion on precedents, or if they only have to abide by the end result ruling. And I believe, having read some of his thoughts on this, is that he believes you only have to abide by the ruling, but you can adjust the reasoning for the ruling.
Okay. And
It's kind of a tangential issue to the death penalty issue, but he does talk about it a little bit.
Following up, you know, he was Justice Namias examining Justice Bethel in his dissent. He was basically pointing out the reasoning. And could you tell us if Justice Bethel's opinion, if that was based on the reasoning and not the holdings of those United States Supreme Court decisions?
There have been lots of cases regarding the death penalty, including cases relating to intellectual disability. You know, like, for example, I think it was, I don't remember if it was the Bethel decision or the Namias decision, looking at other states like Texas. Texas, for example, had a death penalty statute that got struck down as unconstitutional. And so there are probably reasonings that were given for that, but their statute was very different. But they arrived at the conclusion that whatever statutes the states enact, you know, as for the death penalty, if they choose to, right? Many states have chosen to get rid of the death penalty altogether, 23 states, in fact. But for those that do, you know, they still have to abide by constitutional requirements that we cannot go around executing people with intellectual disabilities. But the states are still required to come up with the legal schematic if they want to include the death penalty in their statutes, that it still has to abide by those constitutional standards. So there's various reasonings that are put into some of these other opinions, looking at other states, but the end result is the same, that they cannot execute people with intellectual disabilities. So while this kind of goes beyond the scope of my discussion today, I think that's what Namias is leaning on here, is that, he believes that you only have to abide by the result of the decisions, not necessarily the reasonings.
Representative Bodie.
How you doing, Madam Representative?
Good. Thank you.
I want to say thank you so much for bringing this legislation. I think me and you have been talking about death penalty repeal legislation now for, I think, 2-3 years,
Mhm.
ever since you were originally elected to the House. But I want to say this bill basically, and you might have said this before I walked in, how many other states have done this same thing? States that have a death penalty statute on the books, but has found that, okay, intellectual individuals with disabilities should not be executed. They should not even be in the conversation. Do you have a number? And
Yes. Okay. So if you look at the key points, there might be somebody in the audience here who can give you more precise data, but the fourth bullet point, there are 19 states, and then it names a couple of them
okay,
that impose a standard of preponderance of the evidence. And there are only 23 states that have a death penalty, there are only 27 states that have a death penalty at all. Every state that has changed its laws in response to the Adkins decision, which is the one that, reaffirmed that we should not be executing people with intellectual disabilities, they've all changed their statutes to move to a preponderance of the evidence standard.
and because preponderance of evidence is basically, I know we don't have a firm definition. Some say 51%, a little bit over, a little bit less, but way less than the clear and convincing or beyond a reasonable doubt, which is a very high threshold. So thank you so much for all your work on this. And this is good legislation.
Well, thank you. And if you don't mind, there's actually very strong language in the Bethel decision about that particular issue. And, I know it's dangerous to put numbers, on standards, but, if somebody can reach the 50% plus one standard to be more likely than not intellectually disabled, that would therefore cover everybody who is otherwise found to be and has evidence to be considered intellectually disabled. If we make the standard too high, let's say we change it from 50% plus one to 80%, like under a clear and convincing standard, well, you've just eliminated all of the people who cannot bring evidence, not that they aren't intellectually disabled, just that their evidence isn't strong enough to reach that 80% threshold. And that would be, if you read the Bethel opinion, which I happen to agree with, that would cause people who have legitimate intellectual disabilities to still be subject to the death penalty because they didn't reach that high standard, which is why all of these other states have chosen to use the preponderance of the evidence standard.
Question. And so basically also just thinking the legal premise behind preponderance of evidence, it also just gives the judge more discretion, right? Like the judge can really make that decision because the judge has heard the evidence. They're looking at this human being. They know what the doctors and the therapists and all of the assessments. So that's actually putting the power, more judicial discretion into the judge's hands to make that type of decision.
Yeah, and sometimes it's left to the jury, right?
Yes.
Whereas right now, one of the problems with the statute is that when the jury is receiving instructions, because the language conflates the finding of guilt of the underlying crime with the same standard for finding intellectual disability, they don't really have a choice. There's not really an option under the current statute to find somebody both guilty of the underlying crime, but also intellectually disabled to the point where they should be exempt from the death penalty. So I would agree with, I think, the point you're trying to make, which is that this gives judges and juries, the freedom they need to determine every case on a case-by-case basis instead of being pigeonholed into a situation where perhaps their only other option would be to find that the defendant is not guilty. right? If they did the crime, they need to pay, they need to pay the time. But in this case, we need to make sure that we as a state, we as a legislative body are acknowledging the constitutional rights that are afforded to American citizens, including that those with intellectual disabilities should not be subject to the death penalty.
Thank you.
Chairman Burchett.
Thank you, Mr. Chairman. Representative Moore.
Yeah.
People sometimes don't like to come to this committee because we like to go line by line. I hasten to do that, but I want you to walk me through this bill because it occurs to me the premise of what you're doing, you want to do in adhering to these Supreme Court opinions. I'm generally agreeable to, but it seems like it would be a simple language change. And this is a very significant bill. So I'd like you to tell me what else is this bill doing other than changing the preponderance level standard, because it doesn't seem like that's it.
Yes. So this goes back to the point I was making earlier, which is that the way that the statute is written is it conflates the standard of proof for the finding of guilt and the finding of intellectual disability, which is why you can't just strike out beyond a reasonable doubt and insert the language preponderance of the evidence, because that would then create a preponderance of the evidence for the underlying crime too. Right. So we really did have to craft entirely new language to parse out those two findings. Right. So I'm happy to go through this line by line with you.
Well,
Let's
just
do it.
run through it if you will, and just give me what you think it's doing.
All right. So flipping to page 2, which is really where the changes start occurring. Lines 18 through 29 is mostly about the pretrial motions, for when the criminal defense attorney will raise the issue of intellectual disability. And so there's procedures set forth for that. So if there's a finding of intellectual disability during the pretrial stage, that kind of sets the tone of what's going to happen, right? The defendants can still go through with the trial, but they won't be pursuing the death penalty on that. But it also says that, if the court does not find that they're intellectually disabled during the pretrial phase, that does not preclude the defendant from raising it, in the what do they call it, in the main part of the trial, the case in chief. So that's 18 through 29, and then looking at lines.
Are we changing
31
the
through
definition?
36.
Sorry to interrupt. Are we changing at all the definition of intellectually disabled?
Nope. We are adopting it from another part of the code.
Okay, thank you.
Mhm. Yeah, that's in 18 and 19. 31 through 36 is kind of another part of the procedural aspects of this about raising the claim of intellectual disability. And then flipping to page 3, lines 37 through 45. This is really the crux of it right here, 37 through 45. It says that first, the trier of fact, the judge or the jury will first determine an issue of guilt. That's number 1. Number 2 says that if a guilty verdict is returned, the trier of fact will allow the parties to introduce evidence as to the accused's alleged intellectual disability. Right. So this is what allows the jury to decide separate from the question of guilt. If they're guilty, if they're found guilty, they'll allow them an opportunity to also make a separate determination of intellectual disability. So that's number 2. Number 3 says if the trier of fact determines that the accused is not intellectually disabled, the trial will resume. Right. And then there is one last opportunity for evidence of intellectual disability to use as to be offered as a mitigating circumstance when dealing with sentencing. So that's the main part of what this bill needs to accomplish right there is 37 through 45.
Representative Moore, so 38 through 41, in this hearing, is there an opportunity to appeal whether or not the accused is intellectually disabled?
I would imagine that any criminal case can be appealed, and whether they can narrow the appeal to the intellectual disability part, I don't know. Admittedly, I'm not a criminal defense attorney.
Anybody can speak to that?
Mhm.
Okay, well, come on up. Would you mind if I bring some folks
Sure.
up?
Yeah, let's do it.
It's good to have, no, you're good. I just know him, Mr. Brad Rigby from the Cordell Circuit. Good to see you.
Means we're taking this, line by line. If you don't mind, Mr. Chairman, we can bring some of these folks up.
I would
and-
also like to offer to bring up Representative Gunter, if you'd like,
Yes.
if you want to speak on the bill. See me, want to see here?
Actually right over here, Brad, if you don't mind. Yep, right here.
Come on over, Brad.
Glad y'all made your way up from Cordell. I understand you've had a few trials you've been dealing with. Go ahead.
Well, yes, it does not allow for appeal, and that's part of the problem that we have with the bill. In this, you could have a judge make a determination here, and there's no part of the bill that permits that for the state to take that up on appeal to challenge. If you have a judge that's opposed to the death penalty and you take it in his jurisdiction, then we're out of the game immediately. So that's a huge problem for the state and for the district attorneys around the state.
Would you introduce yourself real quick? If you don't mind?
Sure. I'm Brad Rigby. I'm the district attorney in the Cordell Judicial Circuit. I've tried two death penalty cases in my career. So,
Thank you, Brad. I appreciate
yep,
that.
sure.
In reading this bill, Brad, seems to me like there are three different options for the defendant to raise this issue of intellectual disability. Currently, how many opportunities would a defendant have under current law?
So currently, it would be raised in the guilt innocence phase, and then the defense gets to raise it again in the sentencing phase. Now, I just want to point out that currently in the sentencing phase, the jury can find that the same evidence they heard in the guilt innocence phase could be heard in the sentencing phase, and for any reason they could find because the defendant looked like my brother, I don't want to give him the death penalty. Just one juror on that phase. They can also consider the intellectual disability evidence submitted in the guilt innocence phase in that sentencing phase and find that in fact he doesn't deserve the death penalty at that phase. So right now this would create a third tier, a third trial rather than the two-part trial. What this bill does is creates a third trial before a judge, and then they're going to try it again before a jury under the same standard of evidence. And it just creates yet another impediment in the system. So.
Very good. Thank you.
May I respond just briefly to that?
Sure. And Mr. Rigby, if you'll just hold on, I think we might have a question. Go ahead, Representative Moore.
We're talking about taking somebody's life. I mean, don't they get another shot? I mean, 2 shots at it, fine. 3. Is that really a burden before we take somebody's life? I would say it's still, if you're going to have a death penalty statute on the books, give them a shot. That's it.
Well,
Hold on just a sec. I think, and I'll give you a chance to respond. I do want Representative Bodie to have a chance to ask his question real quick.
Without due respect, Mr. D, I concur with my dear friend and colleague that if it is another step,
Representative Bodie, could you pull your microphone close to you?
if it is, Mr. D, a third step, I don't find that as being impediment at all, because we have to get this right. I'll be completely transparent with you. This is legislation that's needed. And so if it's a situation where you have a person that is intellectually disabled and the judge gets an opportunity to hear more evidence, or we got another standard to go through or another step in the judicial process that has to be made, this is the ultimate. You can't get no more ultimate capital punishment, crime, and such finality that comes with death. This is death. So if a person don't even know what's going on, they can't even comprehend the crime they may have committed. They can't even comprehend what's going on in court. They don't understand the judicial system. They don't understand what they did. I'm not saying that that person is right or that person should be found innocent, but at the same token, do they deserve to die?
Well, the issues you raise are competency issues, which are a different proceeding altogether. So that's going to be something different than intellectually disabled. So that's going to be a different
I
proceeding altogether.
I understand that, Mr. Deere, but it's the same, almost the same premise. Does 1 + 1 = 3? I mean, we have a situation where an individual is intellectually disabled. And what I'm hearing from you, no disrespect, is that we have an extra step that's in the statute that impedes upon the process basically being completed.
Well, you're adding a third. What this bill does, it would add a third step.
But Mr. D, is that a problem though? What's the problem?
The
with
problem
that?
is the safeguards are already built into the system. They're already there. They're given the burden of proof. They have the ability to present that at the guilt innocence phase of trial. They're already given that opportunity. And then in the sentencing phase of trial, they have that same evidence goes before the jury yet again. And one juror, as the jury system we have in this country, one juror can say, I find his intellectual disability is sufficient enough, and we're not going to give him death. And so those safeguards are already there, is all I'm saying. Certainly, we should take every precaution. We don't want to do anything that would, Georgia, in and of itself, was one of the first states that prohibited the death penalty for intellectual disability before this decision even came out. The state of Georgia did that. So we have those steps already into place. It's all I'm trying to say. They're already there. This just adds yet another step that doesn't allow the state to appeal, that doesn't allow the district attorneys to appeal in that situation. And that's my issue with it.
One last follow-up, Mr. Diaz. So if it had a mechanism within the statute and that's added where the state could appeal, would that make you feel a little bit better about this legislation?
It would make me feel a little better. Yes.
Okay, thank you.
Chairman Burchett.
Thank you, Mr. Chairman. The ultimately, what you want to do, Representative Moore, is change the standard by which a intellectually disabled person is determined whether they are intellectually disabled. Right? Is that correct?
Yeah, the standard of proof.
The standard of proof. That's what you're after, is changing that.
Correct.
What were the reasons for adding these other layers that we're talking about now?
To also put a framework in for the procedure for the proceedings to determine whether the defendant is intellectually disabled or not. That's it. As I mentioned before, right now the finding of guilt of the underlying crime and the finding of intellectual disability are conflated as one and the same thing right now. And the gentleman here is correct that, I mentioned this in my earlier testimony, Georgia used to be the most compassionate, the standard leader in doing the right thing in terms of having our death penalty exempt people with intellectual disabilities. The problem came in 2013 when a bill that was unfortunately went through this committee. I know that none of the current members.
Let me correct that real
none of
quick.
the
You
current
said that
members-
earlier. It's not this committee, maybe the same committee, but not
earlier
the same
versions
members.
of this committee
Okay, okay.
yes, not the current members of the committee. They sought to create a new framework that would preserve that compassionate approach towards defendants with intellectual disabilities. But as the drafter of that bill stated on the record, they made a mistake. Right. So this is really just correcting a mistake and puts Georgia back into the category of having constitutionally viable and compassionate death penalty laws as it relates to people with intellectual disabilities. We're trying to go back to that standard.
Would you consider, conversation offline to maybe offer some amendments to your bill?
Oh, of course. Yeah.
Okay.
Yeah. That's the whole point of the committee
All
process
right.
is to
I
perfect
don't
the
want you
bill.
to feel like we're going in on you or anything, but like I said, I like the premise of your bill. I told you that for the first time you came to me. I just want to make sure we get it right. We don't want to be the 2022 version of this committee where 2028 is coming back and, revisiting our work. So I appreciate your patience in answering our questions, and I appreciate you being open-minded.
I appreciate y'all. I'll stay here all day with you if you want.
Representative Sings.
Thank you, Representative Moore, for bringing this to the committee. My question is not a legal one, and it really doesn't change my support of the bill, but I think it's interesting since you brought up the 2013 decision. Do you have any information on death penalty convictions modifying, going up or down in Georgia after 2013 based on what it was prior, since that was a pivotal point
I
of the
can tell,
change?
yeah, I can tell you that of hundreds of death penalty cases, that 0 defendants have been able to successfully prove intellectual disability under the current statute and even the prior one.
Just a small follow-up. What do you have an understanding of the number before that? Was there a certain amount per year? It's okay if you don't have that. I wouldn't have necessarily
There,
brought
there
that.
may be additional speakers in the
Okay.
audience that can answer that
Thank you.
directly. Mhm.
Okay, we got several people signed up to speak on this bill. Mr. Rigby, since you're already up here, if you have anything further to say, you can go ahead and get it out of the way.
Sure, I'll just say a couple of extra things, and back to Mr. Representative Bodie's point from earlier is that Georgia is structured much differently than the other states. So it's almost, when you look at other states comparatively, it's a little bit difficult to kind of compare them. I'll just say it that way because of the procedures that are in effect. Georgia actually allows, in this guilt innocence phase, we allow as many experts, sometimes 3, 4 of the defendants on choosing. Other states, the judge would actually pick an expert for the defendant, and that person would evaluate the defendant and let the defendant's expert then testify. And they would only get what the judge chose. And our statute is set up differently, where the defense can call as many experts as they want in the guilt innocence phase and or in the sentencing phase of the trial to put up that evidence. So Georgia does not limit that as other states do it. So I just wanted to make sure that that was clear to the panel as well. In addition to that, currently there are 40 inmates on death row at present. Changing this statute would again go back and give them a new hearing and start those appeal rights all over again for those particular defendants, which is also a huge concern for the state and for the DAs around the state that have prosecuted those cases that will now have to go back and relitigate those issues yet again that have already been decided in some other aspect. One other thing I'd like to say is the Young decision that was an 8-1 decision that Ms. Moore brought up, Representative Moore brought up, was denied cert yesterday by the U.S. Supreme Court. And because of that, of course, it's saying that Georgia statute is constitutional as it stands, just as there may be some issues with it and problems with it, as Justice Bethel, Justice Namias wanted to address, but cert was denied by the U.S. Supreme Court unanimously yesterday. And that's because the U.S. Supreme Court leaves it to the states to determine how best to proceed within its own jurisdictions. And our procedures, as I said, are different than the other states that are, compared or whatever else. Some states have clear and convincing evidence as the standard rather than preponderance of the evidence. I think there are about 6 states that have clear and convincing as their standard of proof rather than beyond a reasonable doubt. Others do have preponderance of the evidence. That said, there's because of our procedures being different, our unified appeal process, the death penalty decisions are different than those states, then it's kind of hard to compare those kind of just across the board without looking at each one individually, because they're all set up procedurally very differently. So, and then I do have the Chief Assistant District Attorney in the Paulding Circuit, Jesse Evans, here, and he's going to speak on some other matters as well.
Okay, you got a question from Chairman Burchett.
Thank you, Mr. Chairman. So did I hear you say that, are we the only state with a preponderance?
No, we have
beyond reasonable doubt,
doubt.
Yeah.
There are 6 other states that have clear and convincing, and then I don't know the number. Maybe I have it here somewhere that have preponderance of the evidence. It's 19. Thank you. So we may be the only one with beyond a reasonable doubt. That may be the case, but again, the Supreme Court has denied cert on the U.S. Supreme Court has denied cert on that yesterday.
Let me ask you this. Would you be supportive of a measure that changes the standard or lowers the standard, but doesn't input these additional hearings and measures or hearings?
Well, again, as the problem with that is going to be going back and now having to relitigate the 40 defendants that are currently on death row for a new standard. So in that respect, I'm going to be opposed to it.
Okay. Thank you.
Yep.
Representative Sains.
I have a tremendous respect for our district attorneys and the work that y'all do. And my concern when we're here talking about the most appropriate laws for Georgians to be governed, I don't know if we should be led by what issues it's going to cause in terms of re-litigating those prosecutions. I think what the chairman asked, is it the most appropriate standard of proof for those who may have a mental illness to have to prove in court? Whether that causes a ripple effect, which I understand it would, it doesn't lead me to change my mindset on what would be the most appropriate for those who sent me up here to have to deal with if they were facing that issue. But I appreciate you being here. Is that so? Do you see the justification for that change?
So my response to that is simply as I responded before. In Georgia, the law is set up differently in that the defendant can call as many experts as possible to prove, in fact, his intellectual disability beyond a reasonable doubt. He's not limited to one expert. He's limited. He can call whoever he wants to call in both phases of the trial. So there's not a reason to change that, because they're allowed to do all of those things at the trial level as well as the sentencing level. And at the sentencing level, yet again, they can find for any reason. One juror, just all it takes is one juror can say, well, I believe the intellectual disability, and then it's not the death penalty. And so Georgia has already put those things in place for those reasons, and they can call as many experts as they want on those issues. And then one juror in the other phase can make that decision. So I think those things are already in place with the standard of proof where it is.
So, or is it okay to ask a follow-up question with the part where the jurors are making the decision for any reason? Are they bound to that standard of evidence, or are you saying they don't need to have a standard of evidence?
Let me make that clear. So the only burden of proof is in the guilt innocence phase. There is no burden of proof for the defense in the sentencing phase at all whatsoever. They can consider any reason not to give the death penalty. So there's no burden of proof in the sentencing phase.
Sure. Thank you.
Yes, sir.
I have a historical question. And if we had to assign homework, I've been known to do that. Just ask Robert and some of them, Jill from Gactal and Pack. Where did we come up with beyond a reasonable doubt as a standard? Was that rooted in common law, or that's this question for anybody else who comes up? So I'll give you a chance to answer that. I'm just trying to, a little bit of historical context here might help as well. Any other questions from members of the committee? Brad, it's always good to see you. Thank you for coming all the way from Cordell. Thank you for the job you do. Next up.
Come on down.
Next up, we'll hear from Jesse Evans from Paulding County, Georgia, good West Georgia, and partially in the 18th House District. We appreciate you being here with us today. Just tell us who you're with again for the record.
Good afternoon. So I'm Jesse Evans. I'm a 21-year prosecutor. I've spent most of my career in Cobb County, and recently took the appointment in Paulding County neighboring circuit, where I am now the chief assistant for DA Matthew Rollins. So I'm here speaking as a veteran prosecutor. Bulk of my career has been spent prosecuting homicide and cold cases. And I've had quite a bit of experience dealing with capital litigation as a prosecutor as well. So that's my background. So I wanted to just comment about what the bill is versus what I read it not to be. And I think that you all have framed the issue very well. If the intent is to change the standard by which the defense asserts its show of proof of the intellectual disability from beyond a reasonable doubt to the preponderance standard, I think that that's a fair topic for debate, and that's what well and good that we discuss that, because let's not assume that Georgia's doing it the best way at present. I don't think that that's an unreasonable request to talk about that standard. The issue that I have is this does so much more, and when we're talking about capital litigation, in my mind, I don't want to conflate two different issues, because I always think about Crime Victims' Bill of Rights, which I think is equally important when we start talking about capital litigation as well, and sort of the feel good that comes with that as well. The issue that I have with this is that, as a practical effect, it could very well end the death penalty in certain contexts. I mean, that is the practical implications of the bill as drafted here. And I'll start by saying, whenever you look at a proposed bill that is so vastly different than currently what you're doing and comparatively different than what you're doing, one should pause and ask questions about, well, why are we adding layers, for example? Why are we procedurally doing something that doesn't exist anywhere else? Not in competency, not in insanity. There's really no precedent anywhere else in the law where there are literally 3 bites at this apple of intellectual disability. And don't misunderstand. We as prosecutors know intellectual disability, it's not a death penalty case. That is the standard as we sit here now, and one that we abide by. And certainly this prosecutor has pled out cases to different sentences when that's become a legitimate bona fide issue, because that's our responsibility to exercise our discretion when there is bona fide proof of that. The real problem here is that it's not just changing that standard from beyond a reasonable doubt to preponderance. It's giving a third added level to the defense that could give unchecked discretion to the judiciary, and frankly to a single judge that is against the death penalty and against capital litigation. And the remedy for the state's perspective, there is none. There isn't. So the problem area of the bill is the first section that you look at, where it's now added that third layer, the ability to, in a pretrial motion, file and ask for a court to pass upon that. And specifically, if you want to look at the lines that are of concern, 24 and 25 within Part C on page 1, or is that issue where basically it's saying that a judge, by making that judicial finding pre-trial, right, now it's life and outside of the hands of the jury. And that's the bigger concern. So I want to be clear here that if it is a discussion about preponderance versus beyond a reasonable doubt, that's one thing, but this is not. This bill does more. It throws the baby out with the bathwater. And that is the concern from the state's perspective. So let me give a comparison. I was trying to think in my mind, and we had this discussion, my colleagues and I, well, if you wanted to stretch your imagination to try to find a comparable area of law, think about statutory immunity. So for those not versed in criminal law, person kills somebody else, right? That they claim I'm immune from prosecution because I was justified in doing that. Like it or not, some prosecutors do not. There is a mechanism for filing a pretrial motion claiming immunity that's passed upon by the judge. By the way, that standard, I believe, is by the preponderance. So I believe that is the standard. And I'll ask my colleagues to correct me if I'm wrong on that. Thereafter, if that immunity motion is denied, okay, you can still take it to the jury. That's only 2 bites, by the way. It's the closest thing you can come to where there's maybe this 2 bites approach, for lack of a better term. Now, the flip side to that is, if a judge, and I have an anecdote, in a double homicide, found that a convicted felon gang member acted and was immune, by those counts being dismissed pre-trial, the state at least has the ability to appeal that decision. This does not do that. There is no separate appellate mechanism. A judge on his or her own can make that determination that I find that there's an intellectual disability and end complex litigation from the state's perspective and from a victim's rights perspective, merely because that this additional layer has been added there. And that's the real problem with the legislation. If the question is posed as it was posed to DA Rigby, who I have a great deal of respect for, we're friends, we're colleagues, we are cut from the same cloth, so to speak. Hey, would you be open to the discussion of talking about whether we would support legislation that only deals with the issue of preponderance of evidence? That's a different conversation altogether. I'd welcome the opportunity to see that. And as long as it doesn't, again, throw the baby out with the bathwater and create more layers that don't exist right now. We already have an approved system. Anytime that you look at a system and you're saying, well, there's a need to make a change from that, then I think we need to say, well, why is that? And what is the narrow change that can be made here? I will also point out that one other thing that comes to my attention when I think about this. So there's another form of the verdict, for lack of a person could be found guilty but mentally ill. You might even have a significant mental illness, right, above and beyond having an intellectual disability. So those factually and legally could be 2 completely separate things. currently the state of the law is you can get life without parole if you're guilty but mentally ill. This bill reinforces the idea that it's only life if it's intellectual disability. And again, doing a compare and contrast of things of why is that? I think we have to ask the question, well, why are we going to treat that so vastly different when currently, if you're guilty but mentally ill under Georgia law, receiving a sentence of life without the possibility of parole is on the table right now as we speak. So that's another glaring part that stood out to my colleagues and I, that's sort of reinforced in this statute by talking about life sentence to the exclusion of life without parole. Life without parole was put on the table in non-death penalty cases around 2009. So that's currently the state of the law. There was a question about the number of death penalty cases that we're seeing now. Since 2009, anecdotally dramatic decrease. And I think a lot of that has to do with that 2009 change in the law that would authorize a trier of fact, such as a judge, a court, prosecutors, even defense attorneys to say, well, we agree that a plea to life without parole is more advantageous than the risk of death penalty or otherwise.
Okay, thank you. You've got a couple of questions here. Representative Bodie.
Hey, sir.
To my longtime friend.
How are you?
I'm doing well. First of all, Chief DA, Judge Palmer, I appreciate all your work in call. We had cases against each other, and I appreciate your work in the initial stages of the Ahmaud Arbery case. But I do want to ask you a question because you brought up a good point. Line 23, and I just want to ask you if you're opposed to this, if it's a situation where you want some type of, I guess, appellate remedy, being that this is a pretrial hearing and there'll be a pretrial determination. How would you feel about having an interlocutory appeal where, of course, the judge has to sign off on it, goes straight to the Supreme Court of Georgia? They can make the decision on the finding of the trial court, or if, correct me if I'm wrong, that would probably be how procedurally it would work. How would you feel about something? Because what I'm hearing from you and also the prior district attorney is that we need some type of appellate remedy.
Well, I certainly would want to insist on that if you're backing this portion of the bill from 17-7-127, because that currently is not the state of the law and would not be if the bill passes as is. But I don't want to misconstrue my position here. There's no reason to add a third tier to what the process already is just because we have intellectual disability. I mean, we don't do that in guilty but mentally ill. We don't do that in other mental illness contexts. We certainly don't do it really for competency or insanity. Why should it be any different because we're dealing with a different label than those? It would be the only area of the law that I'm aware of where there is a third tier in criminal prosecution of a third bite at the apple on this. And I've scoured my mind and my experience to say, well, where else would we do that? And we don't. And so I'm not in favor of adding layers to this. That's not to say that I'm opposed to a discussion about looking at what the standard is. Those are two different discussions. I hope that answers your question.
Well, no, not really. But I do want to say this. If we as policymakers decide to move forward with the legislation as is, and I completely respect your position and not wanting that third level, would you be okay, or would you feel a little bit better about having an interlocutory appeal as an avenue to address the appeal remedy that you state that currently the bill doesn't have?
I think that only partially addresses the problem that is this bill. And I think that's the simplest way to say it. I think it's problematic to add the layer at all. And I certainly don't want to detract from that being the position that this prosecutor has, and certainly my organization has, and those that I talk to have, because that's not how we do things anywhere else. There's going to be ample opportunity for intellectual disability presented at both the trial of the case in the guilt innocence phase as well as the sentencing phase. There's absolutely no reason that we need to add that just because this is a death penalty case. And note here too, that intellectual disability, you would add that only to death penalty cases and not to other litigation. So take competency as an example. If you file a notice saying that you are incompetent in any case, right, we have to address that issue at a civil proceeding before we can proceed with the criminal. And then at criminal, a different standard for whether you're insane versus whether it's a competency issue. Does that make sense? So this is a context where you're adding something that's not in anywhere else. So say you had intellectual disability and armed robbery, not a death penalty case, right? This legislation would say, well, only in death penalty cases will you be allowed to file a pretrial motion to address those issues, when in other contexts, even involving mental health, we don't have those additional layers, nor is it needed. I think what we're talking about here is you're adding, if the problem you're trying to fix is preponderance, fix that problem, right? But this doesn't just appear to fix that problem. It also adds a bunch of other things, which frankly could quite literally end the death penalty and capital litigation in certain forums, and even within maybe the same judicial circuit, because you might have one judge, right? It just the randomness of the wheel of the assignment of the case, who's going to grant it every time because of whatever reason, their feelings on that. And two other judges in that same circuit wouldn't do the same thing. So, and as we've noted, no appeal remedy of that.
And I just want to point out, I understand everybody's concerned about judges. Just want everybody to realize under the Constitution, we still have the authority to introduce articles of impeachment against judges that do not follow the letter of the law here in the state of Georgia. So just, I get the judge thing, but no, there are safeguards. Representative Sains, are you waving? Okay. All right. Thank you. Good to see you.
Yes, sir.
Let's see. Next, we have Miss Barnes. If you'll just introduce yourself again to the committee. I know it's been a few weeks, but if you'll introduce yourself to us again. Good to see y'all this afternoon.
Good afternoon. Happy to be back in front of this committee on this issue today. Caitlin Barnes, I'm the Public Policy Counsel for the Southern Center for Human Rights. The Southern Center is a nonprofit law firm that has been providing representation to people facing the death penalty for more than 40 years here in Georgia and across the Southeast. I'm here today with all kinds of folks in support of this bill, a coalition of faith leaders and disability rights advocates and criminal legal reform advocates in support of the bill today. But most relevant, and in particular, I want to introduce my colleague, Mike Admirand, who is a senior litigator for the Southern Center for Human Rights in our capital litigation unit, who I hope will be able to bring additional clarity to the conversation and respond to some of the points that have been brought up and some of the questions that have been raised by the committee members. So I'm going to hand it off to Mike now.
Thanks, Caitlin. Thank you, Chairman, and thank you, members of the committee, for allowing me to be here today. As Caitlin said, I have some experience litigating capital cases involving intellectual disability, and I had some prepared remarks ready to go, and then in light of the, we've covered a lot of terrain here this morning, so I'll try to streamline those a bit and reserve whatever time I have for your questions. So just to get us back to first principles here, as has been covered, Georgia has a unique method of determining who is intellectually disabled. In a death penalty case in Georgia, there's no opportunity to present that evidence of the claim until the trial. But then even at trial, this issue gets muddied, because during this first phase of the trial, the state, of course, presents evidence that the person committed the crime. And then only after the state rests can the person present evidence that they're intellectually disabled. And then after the defense rests, it's the state's opportunity to present all of their experts about intellectual disability. And so when all that's done, the jury goes back to deliberate. That's a lot on their plate. They have to determine whether, not only whether the person is guilty beyond a reasonable doubt, which involves one set of facts, complicated facts, heavy facts, but also whether the person is intellectually disabled beyond a reasonable doubt, which involves expert testimony and all these other complicated evaluations about someone's behavioral deficits. And if that sounds confusing, it's because it is. It's also different from how every other state in the country makes this determination. HB 1426 would make a couple of important changes to how Georgia makes this determination. First, it would separate the ID determination from the factual determination of whether the person committed the crime. I think this would make things much easier for litigants and, most importantly, for jurors who are tasked with making life or death decisions in highly charged circumstances. I also slightly want to push back on this notion that we're adding an additional step to the process. What we're really doing is taking the steps that are currently in place and just separating them, making them cleaner for all the parties to follow, and setting rules of the road, thinking about this particularly from the juror's perspective. Here's the issue in the first phase, here's the issue in the second phase. And then if we get there, if we're at the ultimate penalty phase, are there other reasons aside from intellectual disability where the person may or may not be worthy of the death penalty? The second change the bill would make was lower the standard to preponderance of the evidence. And I have a few points to make regarding that change. As we all know, no other state imposes a burden as high as beyond a reasonable doubt. And I respectfully want to disagree with Mr. Evans' comment. Only one other state imposes a clear convincing evidence standard. Every other state imposes preponderance of the evidence. There are a few states, such as Arizona and North Carolina, where they have separate proceedings, where if there's a pretrial hearing and the standard of proof there is one thing, say preponderance, but then at trial, they have a different opportunity, a second bite at the apple, and the state sets it a clear and convincing. And I may have those reversed. I'm not intimately familiar with the particulars of those states' laws, except to the extent that they have separate standards, but they both provide opportunities for a decision maker to make the determination by a preponderance of the evidence. So this change would really bring Georgia in line with the rest of the country and resolve the issue once and for all. I think this change would also make Georgia law internally consistent. This is the only area where Georgia requires someone to prove that he's intellectually disabled beyond a reasonable doubt. In every other context, special education, eligibility for services, Medicaid, and the like, the state uses a lower standard. And there's no reason to have a uniquely high burden when the consequences of getting the determination wrong are the difference between life and death. My third point, and I cannot emphasize this strongly enough, making this change is not opening the floodgates to a bunch of litigation. The Young case has come up already, and in the briefing to the Supreme Court in that case, they said that of the 40 people who are currently on death row, only 4 plausibly have a claim of intellectual disability. As somebody who represents people on death row in Georgia and Alabama, and I've done so in Louisiana, I have never once raised a claim of intellectual disability just because there's a law that says it's unconstitutional. You have to have the evidence to support it. We're not in the business of making frivolous claims. This is not going to open the floodgates to 40 different habeas petitions that forces relitigation of all the facts. And finally, I think Young and other cases over the last few years have made it clear that Georgia's current standard is problematic and that the General Assembly is best positioned to fix it. I encourage you to do so by supporting this bill, which would bring Georgia in line with the rest of the country and ensure that Georgia doesn't execute someone with intellectual disability. I'm happy to answer any questions you have.
You have one so far. Representative Bodie.
Yeah, thank you so much, councilors, for being here. Again, I want to focus on line 23, section C. And I know this may be apples and oranges. My day job, I'm a criminal defense lawyer. So I know the state is saying that we're going to create a third standard, or, but I think about immunity motion. If you have an immunity motion, you file it based upon stand your ground justification. A judge can hear that pre-trial, right? So I know this is a death penalty case, but the judge can hear pre-trial rule and say, no, I'm not going to grant your immunity motion, Mr. Criminal Defense Lawyer or Miss Criminal Defense Lawyer. Then you go to trial, you have a trial. And then once you get to the directed verdict phase, the defense attorney can say, hey, look, based upon the facts, justification should be allowed here, toss the case, dismiss it. Judge can do that. Or the judge can say, no, we're going to go to the state's case. State can have their case, give their case. I'm sorry, defense attorney can have his case, make his evidence, the whole nine. But then they can argue, the defense attorney can argue it all over again and say, look, this is the third time, justification, stand your ground. So that's technically 3 times, right? We got the judge and immunity pretrial motion. We have after the state rests its case with the directed verdict phase of the case. And then the criminal defense attorney makes the same justification argument during their case in chief. So it's not like the third time or having 3 shots at the apple is something foreign within criminal defense and criminal procedure in the state of Georgia. So basically, we would pretty much be doing the same thing here, right? Same concept.
Yes, Representative Bodie. And the way that I think of the pretrial hearing that's included in this bill is that it's actually an opportunity to make things more efficient. Capital cases and capital proceedings take a long time. They cost a lot of money, and there's no reason to go through the heavy expense of a capital trial. If we can resolve ahead of time, this person's intellectually disabled by preponderance of the evidence, life without parole is more appropriate. And I think, at least as I read the bill, I think there is an opportunity for the prosecution to appeal that ruling pretrial through the unified appeal procedure. But if it's not in the bill, I think it's an easy enough fix to address. But the second thing I wanted to say in response to your comment, Representative Bodie, is, even with the pretrial hearing, I don't think that there are 3 bites at the apple with intellectual disability. There would be a pretrial hearing, there would be the separate interim phase during a trial with intellectual disability. And then the sentencing phase, at least in my experience and knowing this community well, that's an opportunity for the defense to present other evidence apart from intellectual disability as to why somebody shouldn't receive the death penalty. What was their upbringing like? Maybe they have a separate mental illness. Maybe they were less culpable in the offense itself. And usually if you've lost at a pretrial hearing, the jury has rejected an intellectual disability claim, you're probably going to be trying to find other reasons as to why your client shouldn't get the death penalty. So I don't even really view the sentencing phase as a 3rd bite at the apple on intellectual disability specifically. I think of that as a separate thing that is constitutionally required through other case law, and I view it as distinct from the issue before the committee today.
Chairman Burchett.
Thank you for your testimony. I'm trying to wrap my head around this here. I don't know that it's 3rd bite at the apple, but it seems to be certainly a 2nd bite at the apple. If you've got a pretrial hearing trying to determine whether or not there's an intellectual disability, that a judge can, alone make the determination. And then in lines 38 through 41, it looks like, again, after the guilt, if there a guilty verdict is returned, the trier of the fact shall allow the parties to introduce evidence again to determine whether or not there's intellectual disability. Do you think that it's not 2 chances there?
No, that would be 2 chances. The pretrial hearing would be a new procedure. I think that would be similar to competency determinations or to immunity determinations, and in that sense would align it. And also a lot of other states do it this way. I know Louisiana in particular, there will be a pretrial hearing. If the defense loses, they can still present that claim to the jury, actually in a procedure that is almost identical to this one.
And so the way I understand this, or the way that you had described it earlier, you want this would make it sort of a bifurcated trial. You try them for guilt or innocence, and then you try them to figure out if they're intellectually disabled. Is that correct?
That's right. Yes, yes. Excuse me. I'm used to appearing for judges. I think for the jury, it would just make the evidentiary presentation cleaner and simpler. Where this first phase, did the person do it or not? And it's about the facts of the crime. The evidence of intellectual disability, as Mr. Evans and DA Rigby said, involves expert testimony and involves a whole separate set of evidence. And I think considering that separately from whether the person did or did not commit the crime.
And if we were to pass it just as it sits now, it's your opinion. So the 40 folks that are sitting on death row now, would they have the ability to avail themselves of this new statute?
I, without going through the, and speaking with all 40 of those clients or with their lawyers, but I think the only lawyers who would attempt to avail themselves of this potential change would be those who have the evidence to support it, those who've raised it in the past but been unsuccessful. And that's a very, very small subset of the people currently on death row.
Very good. Thank you.
Okay. Don't see any more questions.
Thank y'all for your time.
Yep, thank you.
Thank you.
All right, next we have Dr. Alyssa Miller. If you'll just state your name and tell us who you with.
Good afternoon. My name is Dr. Alyssa Miller, and I am the Public Policy Research and Development Director for the Georgia Council on Developmental Disabilities. I also am a clinical psychologist by training, and prior to my current work, I did provide assessment and diagnosis for folks who do have intellectual disabilities. So I wanted to come today and provide maybe a little bit of clinical background. I'm not a legal mind, so just bear with me there. And the other thing that I need y'all to bear with me as well is that I am currently experiencing what people refer to as pregnancy brain. So I am actually just going to read straight from my prepared testimony for y'all, keep it short, and make sure I do not get us off onto any tangents, but happy to answer any questions that y'all might have. So GCDD, as I mentioned, we do support this bill. Again, I know other folks have said that Georgia is the only state who requires a burden of proof beyond a reasonable doubt, which is practically impossible for someone with an intellectual disability to meet. The diagnosis of intellectual disability represents a wide spectrum of functioning and presentations. One reason for the spectrum of presentations is the criteria required to diagnose an intellectual disability. So the DSM-5, which is the diagnostic manual for practitioners, it requires a deficit in intellectual functioning, which I think is what we all kind of consider when we think about it, which is typically what we would think of as an IQ score. This is something that's below 70. It's important to recognize that that's 2 standard deviations below the mean. So 50% of the population given an IQ test would get about a 100. To get a 70, that again is statistically significant, 2 standard deviations below the mean, and is only about 2% of the population. So this isn't something that is an easy diagnosis to receive by any means. But there's also deficits in adaptive functioning that need to be considered, including areas like communication, social skills, school or work functioning, and personal independence. As I mentioned, meeting this criteria is not easy, and it isn't given to just anyone. But that doesn't mean that all people with intellectual disabilities present like what we would consider outdated stereotypes as someone who is childlike and unable to do anything without support. In reality, people with intellectual disabilities can participate in all aspects of community with the right supports. And we can point to, some of y'all might be familiar with, we have in the state of Georgia what's called inclusive post-secondary education programs. And so that actually allows students with intellectual disabilities to attend colleges, again, with the right supports and modified curriculum and things like that. So on one hand, again, there's this wide spectrum. I think a lot of times folks think about an intellectual disability and imagine someone, again, to be someone who is childlike and needs constant supervision, and that just isn't true. And it also makes it nearly impossible for someone to prove beyond a reasonable doubt their intellectual disability to a group who might still be thinking of those outdated stereotypes. I think that's one of the reasons why we are so supportive of this idea of lowering that level of burden of proof. Because again, there are folks who have an idea of what it looks like and what it means to have an intellectual disability that's based on what we've seen in the media or what we've seen in movies or read in books as we were going through school, and that's just simply not true. For these reasons, we do support the proposal to change the burden of proof to a preponderance of the evidence, and we believe it's time for Georgia to correct this requirement and ensure the constitutional rights of Georgians with intellectual disabilities.
Okay, thank you very much. Congratulations, by the way.
Thank you.
Don't know that we have any questions for you. Thank you for taking time out of your day to come and speak to us.
Yeah, perfect.
All right. Next, we have Mr. Brian Nunez. If you'll just state your name for everybody and who you with.
Yes, of course. Good afternoon, Chairman and members of the committee. My name is Brian Nunez, and I'm the Policy Associate for the SPLC Action Fund, our organization of 50C1 dedicated to safeguarding the human and civil rights of all people. We ask that you vote yes on HB 1426 and advance this bill out of committee. Georgia is the only state in the country that still has an incredibly high standard of proof to meet the legal standard for intellectual disabilities. This bill will work to protect vulnerable people from execution. Unfortunately, individuals with intellectual disabilities are more likely to be wrongfully convicted. Exercising your Miranda rights, susceptibility to police integration tactics, and the ability to participate in your defense or testify on your own behalf are all compromised if an individual has an intellectual disability. Those due process protections don't really work when a person has an intellectual disability, and there's no way for the court to adjust for that fact in a trial setting. The only remedy to exclude individuals with an intellectual disability from the death penalty and to make sure that the definition is broad and can accommodate the medical establishment evolving understanding of the subject. Our colleagues at the ACLU have actually a really good list in which people with intellectual disabilities confess and were convicted. Each of these persons were eventually cleared through DNA evidence, but spent many years in prison. So we're just here to strongly encourage the committee to please vote yes on this committee and pass out our committee. Thank you so much. Kept it short and brief for you guys.
Any questions? Thank you for being here. Southern Poverty Law Center, as I understand.
Yes, sir.
You
Yes, sir.
do have a question, Representative Sainz.
Thank you for being here. Real quick, the list you mentioned, is that a Georgia-specific list, or is there a number of the amount of Georgians that are on there?
So I would definitely defer to the Southern Center or any more other colleagues that are here to say, but I do not have the specifics on
I
that.
might have missed it when they're testifying. Thank you.
Thank you so much.
Okay, thank you. All right. Judge Gunner, you weren't wanting to testify. You're just observing today. I value the judge's opinion on this, as I understand you have been a prosecutor, defense lawyer for a short period of time, and judge. So we welcome your perspective if you want to speak.
You want me here or up there?
You can speak right there. I've recognized you.
All right. Thank you, Mr. Chairman, members of the committee. I would caution the committee in adopting legislation that goes too far. I signed on to this bill because I thought it was worth the conversation about the issue of whether we should have an intellectually disabled or potentially intellectually disabled person trying to prove that beyond a reasonable doubt. I think the preponderance of the evidence standard is appropriate from my experience. I declared 4 death penalties and tried 2 successfully. And when I say successfully, it doesn't mean that I enjoyed the verdict. Okay, it was probably one of the saddest things I had to do during my time as a DA. So there's no joy in winning these cases. But I do think that that we should have this conversation, and I think it's very important for the state. And I would encourage you, if you are inclined to make that change, that you narrow this bill down to that issue only. And that would be my comment.
Thank you, Judge. We appreciate your perspective on this. No questions from the committee. Next up, see, we have Miss Julie McGowan. You'll just tell us who you will.
Hi, I'm Julie McGowan. I'm an advocate with the Georgia Advocacy Office. Good afternoon. Thank you for the opportunity to provide information relating to the Georgia standard related to the execution of people with intellectual and developmental disabilities. The Georgia Advocacy Office is Georgia's federally designated protection and advocacy system for people with disabilities. The Georgia Advocacy Office has served in this role since 1977, and at that time, our federal mandate was specific to Georgians with intellectual and developmental disabilities. The stigma and archaic ideas of how a disability presents continues to thrive in Georgia, and the burden of proof to provide a diagnosis of an intellectual disability beyond a reasonable doubt allows members of a jury or judge who are not professionals in this field to be guided by their own bias of who or who isn't impacted by an intellectual and developmental disability. This, coupled with the allegations made against the individual charged, often results in inequitable and inappropriate determinations of responsibility. As GAO advocates, we stand beside people with intellectual disabilities that already face the barriers of bias and judgment to attain a diagnosis and receive the support and services they need. However, requirements for a diagnosis to obtain those services involve clinical analysis, testing, and examinations by professionals in schools and doctors. These avenues are proven to be reliable in diagnosis. Beyond a reasonable doubt leaves that diagnosis to the judgment and bias that exists within people of the jury or a judge. HB 1426 gives justice a more effective avenue by allowing the defense of a person with intellectual disabilities to invite experts and professionals to share evidence within the scope of an acceptable diagnostic practices. It still requires a burden of proof for the defense. That burden of proof is just not insurmountable. The Administration on Community Living estimates that 1.58% of the population experiences an intellectual and developmental disability. Changing the burden of proof will impact a relatively small number of people. However, everyone deserves equal access to the protections of the Eighth Amendment. Thank you.
Okay, I don't see any questions from the committee. Thank you for coming and taking time out of your day to testify before us. All right, next up, we have Miss Jill Travis. If you'll just tell us who you're with. I know most of us know, but for the record.
Good afternoon, Mr. Chairman, members of the committee. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. And I'm here to support fully House Bill 1426 on behalf of my organization. Don't have any prepared remarks, but I want to just comment on some of the things that have been said in the committee process today and commend the author for her courage in bringing forward this bill that's very timely and necessary in this day and age where we have people that have intellectual disabilities. To the question of how did we get here? Why do we have beyond a reasonable doubt? Having written the prior version of this, what you're looking at now, this for a prior version of this, and having written the law that put in an intellectual disability, I can tell you it was an error, very much to the point of Representative Moore's point. What happened was intellectual disability was just placed in, and I'm such a words on paper kind of person. When you look at adding the words, should have highlighted it. If you look at line 53, in all cases in which the defense of insanity, mental illness, or intellectual disability is imposed, etc. All we did a while back was change the terminology from mental retardation to intellectual disability and tried to define it a lot and did define it, what an intellectual disability is. So how do we end up with a beyond a reasonable doubt standard? I would contend it was an error, but it's been a costly error. And it's certainly time to rectify that and to get us back to where other states see us fitting in. This issue of having a pretrial determination is done in many other states. And it's time for Georgia to adopt that standard. To the contention that there is no relief for the prosecutor to seek pretrial review, I would ask the committee to look at section 1-4 of the bill, where you see, I believe that's the unified appeal process, 171035.1, and it certainly allows the Supreme Court to review pretrial determinations of an intellectual disability. So I see that as a red herring. If I am inaccurate in that assessment, then I certainly think that that was an oversight and not an intentional error or craftiness on behalf of Representative Moore to slight the prosecutors from being able to bring forward what they think should be brought forward. The, to the point of like, how can we narrow this, Bill? How can we make it?
Sorry, Mr. Chairman, will you kind of elucidate what you're talking about in this section 1.4? Because I'm not reading it as a means for appeal. Can you tell me what you mean there? It looks like it's referencing a report of some sort, and I'm not sure that brings up appeal for everything.
So in the death penalty space, there is what's known as the unified appeal process. I have to admit to you that I have never, I'm not death penalty qualified, and I have not tried a death penalty case. So I haven't had the privilege of representing somebody in the space and knowing exactly how it works. But I do know that in the death penalty space, that there are certain issues. There's a checklist with the Supreme Court that you go through, and that you can bring up issues before you actually have the trial of the case. And I believe this is the code section 171035.1 that is the unified appeal process. And what they're saying here is in the death penalty space, obviously we don't want anything. For example, if you look at line 204, the recusal of a judge, let's say the defense brought up, or the prosecution brought up the recusal of the judge. You want that issue to go to the Supreme Court and get decided on pretrial before you try the case, because you don't want to try the case, have all of the trappings of what goes into a death penalty case, only to come back and learn, oh, there should have been a recusal granted.
Respectfully, Jill, I defer to your opinion many, many times, but what I'm reading this is just adding in lines 208, we're adding any proceeding with respect to pretrial determination of intellectual disability. I don't see where it is picking up any type of.
If you look at line 200, the questionnaires are designed to determine whether there's any existence of reversible error with respect to the following matters. So if it was reversible, let's say the judge found an intellectual disability and the state wanted that questioned, I believe this is the area where you would do it. So I think that is covered, but I didn't come prepared to answer that question specifically, but I do think it is covered. And if it's not, I think it's something that could be covered easily.
Okay.
A lot of this bill has to do with just using the right terminology, intellectually disabled. And that's just merely a sentence structure. Like we have a definition. And so, for example, if you look at page 9 at line 218, it's changing guilty but with intellectual disability to guilty but intellectually disabled. So this bill is arguably longer than it maybe would want to be, but part of that is just the cross-reference changes and then the cross-references to the other part of the bill. As Representative Moore did state, the crux of the bill is found in the first couple pages, pages 2 and 3. And I do think that as Michael, and I can't ever pronounce his last name, I'm sorry, from the Southern Center of Human Rights, it walks you through the process of the finding the issue of guilt. And I'm looking at the top of page 3, guilt or not guilty, but if a guilty verdict is rendered, then allow the ability to introduce intellectual disability. And then if the finding is not for intellectual disability, then we go into the aggravation and mitigation stages of any kind of death penalty case. And I wouldn't expect that defense the defense would try for a third bite because they've already lost at part two. But it's also not to say that an intellectual disability can't play some role in whatever is listed as a mitigating factor. So that's what I have to offer for the committee this afternoon. I'm happy to answer any questions.
Okay, I think I had one. I saw you nodding earlier. Where did we get this standard? Where did it come from? Historical context. I think you said you might have some wisdom for us on that.
Oh, well, how is this messed up in the first place?
Okay. Well, no, I mean, it wasn't an accusation. It wasn't an accusation at all. Okay, good deal.
I mean, I don't think, y'all been here long enough to know that we all think, we look at words on paper, we think it all makes sense. It all seems to be smooth. And then, oh my gosh, something is overlooked and you didn't realize. I don't think anybody thought we were requiring proof beyond a reasonable doubt on intellectual disability, that it was a thought out process. It's just what happened.
Okay, thank you. Don't see any questions from members of the committee. Jill, thank you for being here, being
Certainly.
diligent and coming to all our committees. All right, next we have, I believe this is Maggie Rousseau. And if you'll just tell us who you're with.
Good afternoon, Mr. Chairman and members. My name's Maggie Rousseau. I'm the Director of the Disabilities Ministry for the Roman Catholic Archdiocese of Atlanta. And I've been involved in advocacy on this issue for a few years now. And I want to bring a personal, just a face to the bill a little bit. I am a mother of a child with an intellectual disability. In September of this year, my son Christopher would have celebrated his 31st birthday, but very sadly, he passed away. I can understand the gut-wrenching loss that the families of the victims feel. That loss is very, very difficult to live with. But I cannot accept that taking the life of a person with an intellectual disability as a punishment for a horrible crime is right and just. I've been living in the disability world for 31 years, first as a mother, after Christopher's passing as a special education teacher here in Georgia, with students of all ages, intellectual disabilities, along with other disabilities, and now in ministry as an advocate. I learned of this issue in 2015, and I can tell you that I was appalled. We are better than that here in Georgia. And I can see the faces of those that this change will protect. They were Christopher's friends. Some are my former students, some were in the classroom next door. I have personally helped families whose adult children have had legal issues because of a disability. And often there is little or no documentation available to help prove a person's lifelong history of living with a disability. In my experience, information from the Department of Education here in Georgia and VOC Rehab is destroyed after 10 years. And the last I investigated that was 3 years ago. I'm not sure whether that's changed. What family in an IEP, an individual education plan meeting, would ever think that they have to keep every document about themselves or their child from infancy throughout adulthood so that they have proof in case they need it to explain their intellectual disability? I won't go over what we've talked about when it comes to what intellectual disability is, but keep in mind that we do look at 3 areas: intellectual functioning, adaptive skills, and then also the age of onset. And ask yourself, if you were a juror, are you qualified to determine whether someone has an intellectual disability? Could you do an assessment? Are you trained? Typically, a jury in Georgia is not made up of individuals who have a strong ability to identify and diagnose an intellectual disability. We do not diminish the loss of life caused by the crime. That life loss is terrible. It's devastating to all of us. But we are not a state of citizens who believe that killing a person with an intellectual disability is the right thing to do. One of the two state of Georgia mottos is wisdom, justice, moderation. We are asking you, our state of Georgia representatives, to use wisdom to guide the Georgia General Assembly to adopt House Bill 1426, to provide justice in the judicial system for an individual with an intellectual disability, and to allow for moderation to encourage fairness in death penalty cases involving convicted individuals with an intellectual disability. Passing House Bill 1426 will align the Georgia standard of proof to the 2002 Supreme Court decision, thereby ensuring that we are respecting the rights of all citizens that are afforded under the U.S. Constitution. And I want to thank you all for everything you do for our state. We have a wonderful state. We just need to do a little bit better, especially for persons who don't have their own voice to come here today to speak to you.
I think you have one question from Representative Saints.
Not necessarily a question. I appreciate you being here. I think the testimony you provided as someone who's advocated firsthand is valuable, and specifically the record retention requirements of our state, if we're going to use provisions in the law, I would hope would be expounded. I know that's out of the purview of this bill, but I think it's worth noting. Thank you.
Thank you.
Pat, I know y'all usually sign up. I know you've had two good prosecutors. Just Robert wanted to extend the opportunity if you wanted to come up and testify for us.
Thank you, Mr. Chairman, but Mr. Evans and Mr. Rigby speak today on behalf of the prosecutors. I'm not going to add anything else.
Okay, thank you. Yes, Chairman Burchett.
Would you mind, Mr. Evans or Robert come up? I do have a follow-up, and you can answer for right there. This bifurcated idea, what is the opposition to that? If we find guilt for the underlying crime and then find whether they're intellectually disabled, what is the issue with that?
So I think we haven't talked about this.
Come on.
I talked about what I think is important of kind of doing a compare and contrast about what we do in other areas of the law and say, well, is there a reason to do something different here? And I would struggle to answer that question about why we should be doing that here when intellectual disability could impact other crimes and other areas of the law. Just because it happens to be a death penalty case, adding a change in the procedure doesn't seem like it's the good way to go just for the sake of change, if that makes sense. I mean, if that truly is the will of the legislature, then shouldn't you be considering globally, is that something that needs to be across the board for all crimes and not just capital litigation cases? So my first blush, my response is, why are we making it more complicated in the most complex case that could be tried in the state of Georgia and not less complicated? If that truly is something that is a problem area, I would just encourage the legislature to pose that question. Why do it different here and not do it in all cases?
I think I get your point, but I think that this is a different case. I mean, what is the ultimate penalty, right? And what is your response to our earlier testimony that the jury of the peers is trying to determine both of those and at the same time versus determining guilt and then determining the intellectual disability?
Sure. Well, they are already tasked with doing that in guilty but mentally ill as well too. So you've got multiple options in terms of the verdict. You can be guilty but mentally ill. You can be a guilty with intellectual disability. You can be not guilty. You could conceivably not guilty by reason of insanity. what you're doing is isolating one of all of those options, the intellectual disability portion, and saying we're going to do it differently here, but only here. And I struggle to see why that should be. If the global fix is to say, well, we don't find it objectionable to do just the guilt and then a separate phase about the intellectual disability, I'm open to having that discussion and seeing what that legislation might look like, but it complicates things from the other aspects of mental health defenses that we deal with as well, such as not guilty by reason of insanity or guilty but mentally ill, because we're not already doing that there. And it's no less of an issue that the jury has to wrestle with all of those things at the same time. That is the current state of the law, but not just death penalty cases, for all cases. And I think that's the concern that I would share.
Thank you. I'm going to ask you one last follow-up, if you don't mind. If we were just changing the standard to preponderance, to the preponderance level, would you be supportive of it?
I might very well. I'd like to see that bill, obviously, and make sure that it's not changing too much. That's a global concern that we have. I certainly would want to speak to my colleagues as well, but I'm not averse to having that discussion. If other jurisdictions across the country have moved to the preponderance standard, and that's the goal of this legislation, is to only change that one narrow aspect, whether it was mistaken or otherwise, that historically the standard of proof was left beyond a reasonable doubt, then sure, I'm open to that discussion and would look at that legislation and might very well support it after speaking with my colleagues, because it seems like quite a lot of other states are doing that too. We were pretty progressive when we were the first state, one of the first states to recognize the importance of protecting the rights of the intellectually disabled. And I'm sure we always need to be thinking about what's broken that needs to be fixed. I just am concerned about breaking things for the sake of breaking things. Yes,
So
sir.
I have one question, if you'll indulge me. I know the hour's late, but a little hypothetical. We all probably have someone that we have back home. I've got a few folks that are fairly close to me. They would probably be considered to have an intellectual disability. What about that individual, though, that has an intellectual disability, a learning challenge, if you will? It's more than just a learning challenge. It truly is intellectual. What if that individual is able to operate a vehicle and is given a driver's license, passes the test to get their driver's license? Are those type of people going to be covered under this? And my question is, and I've talked with some about this, is somebody with ADD, ADHD, I mean, where's the line going to be drawn at? Because even the hypothetical there with the individual that truly has an intellectual disability, but they can hold a minimum wage job and they can drive back and forth to that job, is that who we're covering under this?
It's a great question, and that often is the struggle that we come into when we get to the litigation phase of capital litigation. Is the dueling experts is what we call it. Like there is a DSM-5 definition of intellectual disability. We can all go look it up. Experts can apply that standard to the individual that they're looking at and reach their expert conclusion about whether this person qualifies as being deemed intellectually disabled. But not all experts are going to agree, and that's often what we have to deal with. I think your scenario is more intriguing a question, if I could, to say, well, yeah, are there levels, just like there's levels of people being on the autism spectrum, right? There absolutely is a different standard there for what qualifies as intellectually disabled. And as a legal matter, we know that is too. It also can be implicated by IQ tests and a number of things that can be objectively looked at and studied by these experts as well. But it is definitely sometimes a moving target as you get the experts to start to talk about the specific needs of this individual.
One more follow-up. We were talking about why are we going to treat this case any different than the mental incapacity cases you're talking about. But I think, isn't this the only area where Georgia has said that if you are intellectually disabled, that you will not be put to death?
And part of that, I want to be clear. Well, yes, but part of that I want to be clear is because our Supreme Court has also said that as well. They've said that we find it unconstitutional to put to death somebody that suffers from a legitimate intellectual disability, just like they changed the law regarding the age of the death penalty as well. That was a change that we saw as well, where before, if you were deemed an adult, as all of you know, in Georgia, you can be charged as an adult before you're 18, right? But our Supreme Court has said, well, we find that it's constitutionally an issue to impose the death penalty. I think it was out of Louisiana was that case, to impose the death penalty. So yes, that is something that Georgia sort of codified, but we know that to be true from the precedent as well.
Thank you.
All right. Thank you, sir. Appreciate it.
Thank you.
All right. Yes, if you,
Can I make closing remarks?
yes, of course, of course.
You got anybody else coming?
No, I think we've covered everybody. Anybody else that signed up? Before I forget, I want to recognize our Judge Gunner.
Yeah, thank you. Mr. Chairman, and before Representative Moore gets going, I just want to make sure that my prior comments didn't sound like I was chastising Representative Moore. I appreciate her bringing this bill, and all of these issues are important for us to be talking about. Whether I think it should still be in the bill or not doesn't matter. It's just these are important issues regarding the death penalty and how this state treats other people. So I would just want to make sure she understood that,
Right.
and the public did too.
Right. Before I forget it too, thank you, Judge. I wanted to recognize former legislator with us, Mr. Neal in the back. So glad to have you with us. Representative Bodie, I think you had a question.
I do have to ask a question because when the judge speak, I just, when you got an opportunity, you have a former chief judge in the room, you have to ask him a question. Judge, would you find it to be unduly, if we can go back to your days as a chief judge for Superior Court, section C, line 26, would you find that to impede the process if it was a pretrial hearing to determine intellectual disability? I mean, would that, as a trial judge, would that be something so out of the ordinary out of the other 50 pretrial motions or 100 pretrial motions you're going to hear in the death penalty case?
Short answer is yes. I think the current procedure that we have is adequate. I think what we really need to decide is, do we measure it by beyond a reasonable doubt or preponderance of the evidence? And that's where I'm coming from on this. In fact, the gentleman from Paulding and Cobb counties spoke very well, and I agreed with most of what he said about this issue.
So you're good with changing the standard and bringing it down?
I'm good with changing the standard. I think that is something worth talking about.
Okay.
I don't know how the committee feels about it, but I think it's definitely something we need to be talking about. And I would support that change if it was to come about.
Representative Moore.
All right. Thank you guys for doing this with me. I appreciate it. I know this is heavy stuff, but it's important. There are just a couple of wrap up points that I want to make sure were made and put on the record. I really appreciated Jill's comment about how, this actually is a very short bill. It's the last few pages is just changing the term, right? So I think that this does do a very efficient job at proposing the change that it sounds like nearly everyone in this room supports. And I've let the prosecuting attorneys know that, if they have any substantive changes that, they would like to propose to improve the procedures that we set forth in order to enact this change in the standard, that we can talk about that. So I'm absolutely open to making sure that, everybody understands exactly, what is being proposed, that, it's fair and reasonable, and that, make sure that we as a state, we as legislators that set the policy for our state, that we're abiding by, what the Constitution requires, which is that we do not execute people with intellectual disabilities. It was mentioned earlier that cert was denied in the Young case, the one that prompted this bill, and that came out today. But you know what? Chief Justice Namias predicted that would happen. on page 136 of the Namias opinion. I'm sorry, guys. Thank you. He said that based on the current composition of the Supreme Court, he believed if cert was brought to the US Supreme Court, they would probably deny it. And they did. Which means that the burden to correct this error is on us. The Supreme Court is not going to force us to do it, which makes our role in this that much more important. So I want to thank you guys for your questions, your willingness to talk with me offline about this, your openness to it. I want to thank Judge Gunter for his support and his constructive comments about it all. I think this is a really important change that we need to make. And if we need to review a handful of cases, isn't that a good thing? Don't we want to ensure that we are not executing people with intellectual disabilities? And Chairman, lastly, to your question about, would this apply to people with ADHD? I almost guarantee you it doesn't. But every defendant will have a chance to put forth their arguments in front of a jury, a judge and jury. And if the body of evidence presented suggests that they do have an intellectual disability that would exempt them from the death penalty, then so be it. But it's hard to imagine hypotheticals without looking at a fact-specific case. There is some data that shows that the number of people who bring forward a claim of intellectual disability, less than half of them succeed. And in Georgia, because of the way the statute is written, 0 people have succeeded in bringing it forward because of this high standard of proof. So there were comments made about how many opportunities somebody has to present the evidence, but what does it matter if they can't reach the burden of proof? The state has said that they want an opportunity to appeal. If this committee believes that that's something we should add to the bill, then let's have that discussion. But I can't help but notice how they want to add layers for themselves. They want to add layers of protection for the state, but they object to the layers of protection for the defendant. These are people who cannot speak for themselves, and we have to speak up for them. And I'm open to changes, but I would ask that this committee favorably approve the bill. And I promise you, if we can get it through the main House chamber, there are some Republican leaders in the Senate who are prepared to guide it through that chamber right now. And I think that this is something that we can walk away from this legislative session being very proud that we did. So sorry, I got emotional. Thank you. And of course, I'm happy to answer any additional questions.
Chairman Burchett.
Representative Moore, I want to just commend you for bringing the bill and the courage it takes to bring something like this. And I admire your compassion and your passion for this subject matter. I think we've done a diligent job of working through this bill, and the underlying concept of the level of or the standard. I think all of us agree on. I think we're arguing about the semantics or the procedure, excuse me. And I think if we can get the interested parties in the room offline, I think we can come to an area where we're all happy to some degree. So I again appreciate you and thank you for bringing it.
All right, thank you.
Representative Bodie.
No, I was going to say basically the same thing that the chair said. I think we all agree that the standard is much too high in this circumstance, and it's not in line with the national standards across this country. I'm asking you the same question that I asked Representative Garner. Would you be okay with us taking this bill? Because it is motivation to move this legislation, first and foremost, because I think we have shown that if we were to make that one change to change the standard, would you be okay with that and to move the bill forward?
If whatever it takes to move this bill forward in the spirit of why it wasn't proposed, then yes.
Okay, thank you. Thank you so much for all your hard work, Representative Moore.
Thank you.
Representative Moore, thank you. To everyone who testified today, thank y'all for taking the time. Thank you for staying with us. I know this is a very heavy topic, and appreciate y'all's diligence today. With that, we are adjourned.